Hi again and welcome back everyone, it's Paul Tilley. Today in this unit we're looking at some of the other issues related to contract law.
And we looked at this issue of capacity to, age, insanity, under the influence, legality, and this issue of intention. I have to have an intention to enter in a contract with you, and you have to have an intention to enter in a contract with me. We both need to have clear intentions of what we're at. If that intention can be shown not to exist, there is no contract. We looked at this minors issue and the fact that in Newfoundland, a minor is someone under the age of 19. And this has all kinds of implications because if employment contracts is a classic one, how do you hire someone under 19 and enforce a contract with them? Well, you're not going to be able to. Simple as that. And you can't go after the parents. You can't force the parents to do it. Minors can be bound for contracts that are for necessities. Now, defining what a necessity is really something that the court would end up doing. Okay, so now we talked about insanity, under the influence, and how that can come out. Now, stuff that needs to be in writing. Some contracts absolutely positively need to be in writing. This is because the stakes are so high in them, number one. So they usually are involving a lot of money. So we need really clear understanding. But further than that, it comes to a public policy issue. If I sell you a piece of land verbally, and you pay me the price that we agreed to, and the contract goes through, fine and dandy, okay. And you could say, well, what in the heck do anyone outside, talk about privity of contract, what difference does it make anyone outside if you and I make an agreement, sell a piece of land, we trade the land for the money, everybody's happy, right? Wrong. The reason is that land is something that is there's public asset involved or a public good involved in land. For example, the property that my house sits on is adjacent to the property that the next owner's house lives on. I can't take some of his land or some of mine. So what the government has is they have what's called a registry of deeds. And the registry of deeds ensures that all land sales are registered so that the government knows who owns what piece of land, okay? And that's important because, we end up with legal disputes of people trespassing on people's land or these sorts of things, or people sell land that's not their own. So government says, in order to be clear in terms of what land got transferred, how much got transferred, what it was, we're going to set up some rules that say land transfers need a certain standard of care, okay? And part of that standard of care for it to be in writing. It serves a public good because down the road, particularly, it's easy to say, well, people would remember that, but people's memory fade over years. And in my dealings with the town, for example, we have had probably, in my experience being on council for the last 15 years, I've probably seen 5 or 6 cases where land was not clearly registered and it's someone's word against someone else's. And that is really frustrating because nobody's going to win out of that. So the courts have ruled that says land gotta be in writing. Contracts extending past a year have to be in writing too. And it's because people's memories fade and getting information straight when it extends past a year is very difficult to do. So again, the government has said we've seen too many cases where people are complaining about contracts that go beyond a year that are not in writing. Let's enforce the law that says they have to be in writing. Sale of Goods Act, which is the piece of legislation that covers this sort of thing, specifies what needs to be in writing and what needs to be written. So when we look at the Sale of Goods Act, which we'll look at in a later unit, it lays out some details of what exactly needs to be done, okay? So it sets up a clear set of rules for everyone to follow. The partial completion of a contract can take the place of a written agreement. And this has been in the courts too. And the typical situation, what we have is someone contracts someone to build a house for them, okay? So the house is halfway built, tremendous amount of effort and resources have gone into it. And someone says, no, I don't have a contract with you. So someone basically walks away from the deal. So the builder is left with this half-constructed house that he or she is on the hook for. And there's been too many cases of that. So what the courts have said is, in the case where you have something that involves a fairly large project that has, you can measure the percentage of completion, what we're going to do is we're going to enforce the contract to the percentage of completion. So if half the house is done, the house is worth $100,000, $50,000 worth of work is going to be done. The courts will rule on it such as that. Oh, mistakes happen in contracts. Mistakes tend to be problematic because what they do is they put one of the parties, for sure one of the parties, maybe both, but they put one of the parties in a situation where they didn't know what they were getting into, okay? And we know that when a party doesn't know what they're getting into, that can basically nullify the contract. So first of all, the courts have broken it down into the various types of mistakes that are being made, okay? The first one is called a one-sided mistake. And that's where you and I have an agreement. You, me, you understand it, I don't. I am making a mistake. I went and plowed, but I didn't plow your driveway. I plowed your brother's driveway. That was a mistake, okay? You were clear, I was not. So whenever we get a one-sided mistake, which is called a unilateral mistake, it doesn't normally affect the contract's validity unless the mistake was recognized and not reported by the other party, okay? So if you watched me plow the driveway of your brother and didn't tell me, the court's going to look at that and say, well, you know, you had a duty to tell him. You know, anyone can make a mistake. It recognizes that anyone can make a mistake, and that really I did, honest to goodness, do what we agreed to do. I plowed your driveway. The fact of the matter was that I didn't really plow yours. I plowed your brother's, and it was a mistake on my part that you recognized, but you didn't stop. So this concept of caveat emptor, which is buyer beware, it's a Latin word that buyer beware, usually applies unless the mistake goes to the nature of the contract. So, you know, what I mean by go to the nature of the contract, did we effectively do what we agreed to do is the question that's going to be asked. So one-sided mistakes, the courts will look at those and try to say, did the contract actually occur, and did it occur, would a normal person do that, make that mistake? And if they did, well, you know, the court's going to say, we can't help you really. The contract was, for all intents and purposes, completed. The next situation is what we got, what's called a shared mistake, and that's where you and I both make a mistake in the contract. I think I'm selling you this car. You think you're buying this car, and it turns out we both weren't aware that that wasn't the car that we were talking about. It was one next to it. So that's what's called a shared mistake. So if both sides make an error, the contract is voided. And that's understandable because neither you nor I benefit from the contract, nor you nor I get exactly what we bargained for. So it would make sense that the court would say, what we're going to do is put everyone back in the situation they were before any of this happened. Hence, we will void the contract. A misunderstanding is a similar, it could be both or it could be one of us. And it's very similar to the ones above. So these mutual mistakes are most common in court, okay? Courts determine the most reasonable interpretation of the terms of the contract. Sometimes courts will look outside the contract to interpret the meaning. Where terms are not clear, no outside evidence is allowed. Okay, so this is where we make a contract and we really didn't understand what we wanted. We didn't understand or didn't make it clear what we wanted. Neither one of us were really sure what we were doing. Oh, I thought you wanted is a typical response that comes out of it. And this This is the type of thing, I want you to build me a shed, you built me a house, that sort of thing. It was a misunderstanding. So if the terms of and these normally happen in verbal agreements, because a written agreement helps resolve that, because you can very clearly read what is exactly required. But contracts can be complicated, projects can be complicated, these mistakes can happen. So what effectively we can do from a court point of view, the court will look at it and say, what's reasonable here? What was the reasonable understanding? And the court will assess if whatever we can do to put people back in the position they were before any of this happened, that's what we'll do. There is the situation too where you get into unclear terms. Did you mean, like, if we're saying 60, I'm going to plow 60 of snow, and nobody can read what 60 feet, 60 meters, 60 inches, 60 tons, 60 gallons. We don't know. So these are some things the court, looking at the evidence, could interpret that and say the reasonable person would assume this means this. But the problem with it is the court can't go too far, because there is such a thing as the parole evidence rule. And the parole evidence rule basically says that you can't bring in stuff outside of the agreement in order to interpret the agreement. So the court only has so much ability to manage this. So, and also misunderstandings can come about because of fraud. I lied to you, basically. So a fraud, or it could be a misunderstanding because I was pressured to do something. And my state was of the time that I was easily pressured. The old lady who bought the Electrolux vacuum cleaner because she couldn't get the man to leave her house. So those are some things that come into play. We've got this piece of legislation called the Sale of Goods Act out there. And the Sale of Goods Act is a piece of legislation that clearly outlines what it is that people need to do in order to buy and sell certain things. I just wanted to show you the table of contents of it, okay? So it outlines the deal of what's required for a formation of contract. So contract of sale, capacity of contract, form of the contract, sale of goods greater than $50, goods that are subject to contract, loss of specific goods before the contract is getting into frustration, the price of the goods, third-party valuation, if we're buying blueberries, right? Who's assessing how much those blueberries are worth? And we'll talk about getting an assessor, or like some third person to come in and value how much the blueberries are worth. Conditions of sales: the blueberries must be ripe in order to buy them. That's a condition. Effects on the contract: sale of unascertained or undescribed goods, and we'll look at that in great detail when we look at this. The right of disposal, getting rid of the goods. Who owns the risk of the goods? When does risk change hands? So if you buy it and suddenly from space a giant meteorite comes down and smashes it to bits, who's responsible for it? Do you, if I'm selling you the car, let's assume it's a car, and we agree on to a deal, $1,000, you can have the car. Suddenly, poof, out of this comes a giant meteorite, lands on it, blows the car to pieces. Whose loss is it? Is it my loss or your loss? Did you buy the car before the meteorite smashed it, or did I? Sale of Goods Act lays out when the transfer occurs. Talks about performance of the contract, how it needs to be completed, such as when it's delivered and the like. Right of unpaid seller against the goods. What are the rights if like the repossession rights we're talking about here? The various actions that are available in case of breach. So this is what the Sale of Goods Act does, is it lays out legislation for, I'll call it, common problems that occur in contracts. Another key issue that we look at here is the enforcement of contract. And well, this is where we run into problems where you and I have an agreement. I'm going to plow your snow. You're going to give me $20. And suddenly the snow doesn't get plowed. Okay, so you go to court and you say, I want you, court, to force Tilley to plow my driveway. Well, let's look at some of the issues that can come up from that scenario. First of all, there's such a thing as misrepresentation. Misrepresentation is basically a lie. Okay, you could say, I lied. I misrepresented myself as a snow clearer to you, and you agreed to pay me for something that I don't know anything about. Now, let's look at the various forms of misrepresentation. Well, there's innocent misrepresentation, which is a false statement of material fact by the defendant who was unaware at the time the contract is signing that the statement was untrue. So I say to you, sure thing, I can plow your driveway. I have a truck. But unbeknownst to me, the truck just caught fire and burned back at my house, and I did not know that it was up in smoke. That's what's called innocent misrepresentation. I honestly was unable to plow your driveway because when the truck disappeared, I didn't know it was gone. The one that's a little heavier is the fraudulent misrepresentation. And this is really a lie. So it's any type of lie or false statement that's used to trick the person into the agreement. So I say to you, yeah, I can plow your driveway in 2 minutes with this piece of equipment. Now, I know that to be untrue. You got a mile-long driveway. I can't go down that road at 30 miles an hour and plow snow. You physically can't do that. So I misrepresented myself knowing that I was lying to you. That's a much higher problem than the first one where I didn't know I was lying to you, okay? The fraudulent misrepresentation and negligent misrepresentation are very similar because negligent representation is made carelessly and in breach of the duty owed to you. Basically, I owed you a duty to take reasonable care, and basically I got sloppy. Okay, I didn't do it purposely necessarily. Fraudulent means I did it deceitfully. But negligent means I should have told you that it's going to take more than an hour to clean your driveway. I thought you would know that it takes longer than that to clear the driveway. And you say, no, I didn't know that. Well, that's really negligent misrepresentation. If you needed the driveway cleared in less than an hour, I didn't tell you I couldn't do it in less than an hour, that would be considered as negligent misrepresentation. Even stronger again in terms of the problems that we can have is fraud. Fraud means I basically was a shyster, and through use of something such as information to commit a crime that often entails the theft of money or data. So this is criminal fraud. This is really I went and I ripped off your $20 and I ran away. I basically just stole $20 from you. I didn't clear your driveway. I didn't do anything. My intention was never to do anything. That would be criminal fraud. Undue influence. Let's assume that I come into your driveway and I lower the blade of my tractor on your car. I lower it on top of your car. And I say, I'm going to crush your car now until if you don't sign this contract to let me plow your driveway for $20. And you say, okay, I'll sign it. That's what we call undue influence. You did not enter into an agreement with me of your own free will. You did it because you felt forced. And that was called undue influence. And the court will look at that and say, and we're not going to enforce that contract. It was done by undue influence. The other and final one that's there is this concept of unconscionability. Unconscionability means that it is just so heinous or so bad or so extremely unjust or so ridiculous that the court will not uphold it. I say to you, I'm going to plow your driveway. I'm going to charge you $200,000 for plowing that driveway. Your driveway is only 10 feet long. And, you know, you say, okay, maybe that you were not altogether there. Maybe you felt duress. Maybe you felt threatened. I don't know. But the court would look at it and say, look, it's not reasonable at all that you would charge that much money to do something that is that small. It's just unconscionable. It's just not acceptable, and the court will not it will basically ignore that. So what are some of the remedies that are involved in any of those situations? Well, innocent misrepresentation, that's where I said to you, I'd plow your driveway with my truck. Oh boy, I didn't realize my truck just got far. The only thing that the courts would say there is, look, let's tear up the contract, rescission. You know, I didn't hurt you, you didn't hurt me, no one's worse off. You know, I don't have a truck anymore, but in terms of our contract, there's nothing really at loss. Fraudulent misrepresentation is when I lied to you. Yeah, it would eliminate contract, but you are also consuming in tort law for lying to you. So maybe you have to prove that there's damages. Okay, there's damages for whatever happened, and you can sue me in tort for that. Negligent representation, essentially the same thing. You know, I lied to you, or I didn't really lie to you, but I certainly didn't tell you the truth. I was negligent. I should have done a better job at telling you, you know, here's the situation. I didn't. Again, you could look for damages. And a misstatement. So basically, I misstated something. Again, rescission of the contract, and possibly you could get damages there. We also look at this concept of privity contract, and I've already talked about it, but effectively privity contract means that the contract is private between you and me to do something, to agree to do something. If we agreed on it, we're all good with it. It's nobody else's business. And effectively, the court says we're going to uphold that principle whenever we look at things. So what happens is that the court says we're going to look at the contract on its face. Here is what is written down here. We're not going to drag any new information into this. We're just going to look at the contract. That's it. Nothing else is going to enter into it. So whenever we make a decision, we base it on what's in the contract, nothing more. And the good thing about privity contract from our point of view is if you and I sign it, we agreed to it, and there's nothing wrong with it, not illegal, there's no issues with it, we're bound by it. Now, there is some exceptions, and as I say, usually things that involve government statutes, such as the statute of frauds or the Sale of Goods Act or these sorts of things. So interest in land, as we've talked about, this idea of things having been written in land and has a public interest. Trusts. Now, trusts are effectively money that is belonging to someone else that someone has taken responsibility for. So, for example, if I were killed tomorrow, my assets would go in trust, and my lawyers would be responsible for making sure those assets are distributed and all my debts are paid off. So they're going to handle it. They're just acting on my behalf, okay? So that runs into an interesting situation. So sometimes trust legislation is such that the courts can look at that and say, we'll bring in some new data. Life insurance, very similar to a trust, is I'm buying a contract with a company to insure me for my life, and they're going to want as much information as possible in order to make a decision whether to pay that contract out. A couple little small finer points here. Again, I don't want to get too caught up in these, but there is this issue of assignment. And the word assignment means that I can assign the contract to someone else. Okay, let's go to the scenario of the plowing the road. Okay, you and I reach an agreement for $20. I'll plow your driveway. We know what the driveway is. We've written it. The consideration is $20 and the plowed driveway. I say after I walk away from you there and we shake hands and all's good, I say, now I'm going to get my brother to plow that driveway, not me. So basically, I'm going to take the contract that I just signed with you and ask someone else to do it. That's what's called assignment. So basically, I get an employee or someone else to do the actual work. Now, the trick is, who is the contract with? Well, the contract is with you and me. Privity of contract means that you and I are the ones that are dealing in this contract. There's a third person coming in, and that third person is getting involved here. What if the third person doesn't do the work? You can't sue, like if my brother is supposed to plow the driveway, because you can't really sue my brother because you don't have a contract with my brother. You got a contract with me. So effectively, the assignment of a contract causes some problems in law, because a lot of time, like, companies will hire subcontractors, for example, and that's the same as an assignment, right? We're getting a subcontractor to do it. So if the person providing the benefit fails to perform, the assigned person owed the obligation, then the assigned person cannot sue directly. So we got this issue of privity. So effectively, legislation has been put in place to ensure, from a sale of goods, that if you do have an assignment, that you are the one who can be sued. If my brother don't plow your driveway, and I've told him to do it, you got to sue me. And then the court will look at it and say, well, the assignee didn't do the job, but the contract is me. I'm going to be the one responsible for it. So you can see that this triangle situation. Another little interesting foible, again, we won't get too much caught up on this because these things are going away now. Checks is what I'm talking about. Negotiable instruments, such as a check. And effectively, a check is something that allows us to write on a sheet of paper and give it to our bank. And we're basically telling our bank, pay someone else out of my bank account for this. So we're assigning, okay, I go up to the store, whatever the store is, and I write a check for my groceries, okay? I write a check for my groceries. So effectively, the contract is with me and the store when I buy those groceries. The contract is for groceries. But I have taken a check, so I basically said to my bank, would you please pay for these out of my bank account? So it's similar to assigning the debt to someone else. And the question is now, how do we force that to happen? And the courts have ruled on this, and they say, well, we got to find who the holder in due course is. In other words, who really owns the contract, and that's who pays the bill. So what would happen is, like, for example, the check, let's assume the check was a bounce check. The store would not get the money. The bank then would come to me and say that check got refused, and I'd have to deal with the store to pay the store. We're looking at breach of contract too, just a little bit of information there on breaches, what happens when something fails in the contract. And, there's a bunch of these remedies, for example, performance and breach. So if I repudiate before the performance is due, basically I say I can't do it. So you can sue. I basically tell you, after we've made an agreement to plow your drive, I can't do it. You could sue me to get it done. Or if after the performance is due, you could say, you sue me. Failure to perform, again, you can sue me. Partial performance, and this is where the court looks at it and says, partial completion, partial payment. Complete performance, I must fulfill the contract obligations. Performance tendered but refused, I basically try to plow your driveway, you don't allow me to do it. We've got an agreement. I should be able to fulfill it. So the courts would say, yeah, go ahead and plow the driveway. And we see various remedies there for problems. Damages. I could sue for damages. I could sue for what's called liquidated damages. So Basically, you got a car, I could get that car sold and take the money that you owe me. So basically, I repossess it, sell it, and I'd get the money for it. Specific performance, I can sue to make you do whatever we agree to do. Injunction, I can sue to stop you doing anything that you're supposed to do. The accounting people need to disclose the full payment. And quantum merit is if half of it's performed, I owe you half the amount of money, the portion. Little bit here too on implied conditions and warranties. In a contract, if we have a contract to plow a driveway, is there some implied condition or warranty? So it really depends on the driveway case, but lots of other things that we have contracts with, there are implied warranties or implied conditions with it. So sales contracts can have express or implied conditions and warranties. So if I go up to Walmart and I buy an alarm clock and I bring it home, it doesn't work, I paid for an alarm clock. I didn't get an alarm clock. I got something else. So again, the implied conditions are that it needs to be fit so I can bring it back. When we look at the Sale of Goods Act, we'll see the timelines that are involved in that. So there's express warranties. A warranty is effectively, instead of stopping the contract, so for example, I could bring back the clock and get my money back, a warranty says that they're obliged to fix it to make it work. Implied conditions should be, stuff. If I go buy some carrots at Sobeys, the condition of fitness, they should be fit to eat, right? Otherwise, that I could undo that. And again, when we look at the Sale of Goods Act, these implied conditions and warranties are clearly labeled in that, and we'll see this a little bit more. So many sellers add disclaimer clauses to contracts to lessen the risk of being sued for breach of implied warranties. These clauses are often the fine print, generally the courts will look at the fine print and say, does it meet the standard?